forget certain words of 184.3. We don't have additional powers, we have lesser powers in the High Courts.
Clause 3, my lord.
पूरा पढ़ें.
जी.
One जो government वाला है ना.
Should I read 1 and 2 as well? Yeah, 3 पढ़ दूँ.
3 पढ़.
3 पढ़ दूँ. Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article 199. So the High Court, you don't have to go for public importance matter, you don't have to go for enforcement of fundamental rights, you can still go to the High Court. Here, we don't have extra powers, we have the same powers as the High Court, but we have 2 restrictions, public importance and enforcement of fundamental rights. Public importance is variable, let's stick to fundamental rights. So the power here is not a much larger power. My reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably. And then we can sit in 184 as an appeal. Then we have more powers. I don't know, am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed.
आगे बढ़ते हैं.
My lord.
I know you press for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So,
public importance with reference to the enforcement. With reference to the enforcement.
Here, fundamental, public importance, fine. Both parties are there. Now, had it been infringement, then you were right that there has to be a right which was infringed. Here, it's more wider. It's enforcement. So they are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain, can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them, while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this law is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement however, uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I mean, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well.
Attorney General,
my lord.
On my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements हैं, वो fulfill होती है? Because there is no enforcement of fundamental rights.
My lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So
if we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord. Please.
Well, अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
I'm not
be
talking of
affected?
fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law...
Again, that is happening, which I must, interject. I would, you have agreed with now here, I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें, फिर आप note कर लें सवाल.
I just this part I just
conclude. If I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires law is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but,
Yes,
but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where,
being public.
where the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law which is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
now let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under clause 3 or required under clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184.3 on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement.
With reference to the enforcement of.
That you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined under 190.
Is it not a right that everyone has under the Constitution
My Lord,
that laws are made in a particular way?
Legislative competence, of course, as we understand, as I understand it, what you have to see in the act when is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the Constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue, and it is not permissible under 184.3
So
to touch.
in your opinion, the law is good law, parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it? And does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is suspended?
I think my
still
Justice colleague has raised a very valid point, and I was thinking about it during the break. If we read the right of appeal, first of all, it talks about an aggrieved person. Now, I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court, so that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think The 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 184.3 can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain provisions that have been challenged before the High Court. Could we entertain it on 184.3? After all, it is a legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power. You've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, this person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us?
आगे बढ़े थोड़ा सा. If I may, sorry, here, take you back to what you were saying about, and I understand your point relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing because it doesn't. It has to. It's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So he may care on.
Yes.
But breach of legislative competence contrary to the public interest. Until it is related to fundamental right, 184.3 cannot be invoked. This is your argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your Lordship, so before this court under 184.3, these are the 2 things which are to be examined at first instance. Now, once this threshold is met, then, and the burden is just discharged.
Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. Have your right of appeal been taken away? Have your right of cross-examination been taken away? Have your right of a statement under 340 been taken away?
So that's where then it takes me, my Lord, and I just addressing your question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is masters of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue. I think we have our own views and opinions. आप चलें आगे.
My lord. Now,
you have to persuade us, not we have to persuade you.
Just one question I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence ki baat kar raha hu.
Let's consider what this law did. Maybe tomorrow that very matter comes before us.
So the question is.
A second appeal. My lord's question is a second appeal would be
not at all. I am questioning the competence.
Yeah.
The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, can be provided by ordinary legislation? The example I gave you was an extreme example. The first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any provision in the Constitution preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो enlarge किया, पहले एक अपील थी अब हमने दूसरी कर दी है तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
Noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can be
proceeded
under Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
How that can be moved before the Supreme High Court under Article 199 of the Constitution?
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, however expansively the term law is defined. My lord, Article 260 has two definitions. One is of an Act of Parliament and the other is of a federal law. Here we are dealing with the federal law. Article 260 defines the federal law. It says...
You say over here law includes statute law.
Yes. Yes. In my respectful submission, law can only have one meaning, as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
If it's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles, and so you have to, the interpretation has to be given to the word law, and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you
legislative...
look at 75(3)?
जी 75(3) and 141 and 142 as well.
पढ़ लेते हैं जरा, उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura.
So law is what happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says, the state shall not make any law. Now, the state is not just the Parliament, the state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any taxes.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. You don't say federal law.
It does not. What I'm saying is,
I have a question for you. Suppose a provincial assembly under Article 191 law बना देती है, बना सकती है?
Oh, 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot. The answer, because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175(2 for that matter.
Respect, I draw your attention to entry 58.
Relates to the federation
entry
also.
58
Yes.
Ji. Kindly read it.
Matters which under the Constitution are within the legislative competence of Parliament or relate to the Federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. The power that is specifically conferred on Parliament to make statute law and in terms of Article 191 is relatable to entry 58. Entry 55 has got nothing to do with Article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here there is a direct grant by the by a specific article of the Constitution on Parliament, as opposed to the general grant as conferred by Articles 141, 142 and so on. That's a general grant. This is a specific grant. Because precisely it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that entry 51 has no relevance for the present issue.
Entry
55. Has no relevance. This is a matter between, insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that? Keep it in mind and move on.
Well, now, my lord, if my lords may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here is the word is law, so you can read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution,
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ